Trump's DOJ just yanked a buried gun law out of the grave. And for the first time in over 30 years, folks with old, nonviolent records might actually get their gun rights back. It's bold, it's chaotic, and it's already got anti-gunners melting down. Some gun owners are fired up, tipping their hat to Trump and Bondi like it's a done deal. But hold on, should they be? In this video, we'll break down how this proposed rule might reopen the door for people who've done their time, and why that same door could slam shut just as fast. We'll talk Mel Gibson, a Utah mom who lost her 2A rights due to a bad check, the Supreme Court battle no one's watching, and how Trump's crew could be pulling a legal end run with no one the wiser. Let's roll right into what actually dropped on July 18th. Out of nowhere, Pam Bondi, the attorney general that the mainstream press keeps pretending doesn't exist, filed a 48-page notice that drags an old law, Section 9 to 25C, back from the grave. Picture it like the government's dusty spare key. For decades, that key could have opened the door for people with nonviolent records to get their gun rights back. But Congress stuck it in a drawer in '92 and walked away. Bondi just dug it out, brushed it off, and told the Department of Justice to start cutting keys again. Technically, she calls it a proposed rule, which means nothing's final yet. But the blueprint is on the table, and that's already more movement than we've seen from any administration in 30-plus years. Now, the newsroom hot takes try to sell this as a blanket pardon. It's not. The rule carves people into lanes fast. If you've got a violent felony, a sex crime, or a stalking rap that shows you're the guy everyone crosses the street to avoid, you're still on the curb. If you're an illegal immigrant, same story. Same for fugitives, chronic drug users, folks under domestic violence restraining orders. Bondi's language calls them presumptively ineligible and says they'd need extraordinary circumstances to even get a meeting, which is lawyer speak for don't bother. But if your rap sheet looks more like dumb mistakes, tax mess-ups, writing bad checks, fishing without the right tag, there's finally a door with a handle instead of concrete. Here's the clock they built around that door. Nonviolent felonies need a 5-year cooling-off period after you finish everything. Probation, parole, fines, community service, the whole works. Misdemeanor domestic violence or drug distribution convictions get a 10-year timer, because they're closer to violence in the DOJ's eyes. Fair? Debatable. At least there's a number now instead of infinity. And before anybody says 5 or 10 years is nothing, remember how the system used to be. Lifetime exile, zero path back, unless you knew a governor with a golden pen. That's why March's quiet test run made so many people blink. Bondi restored firearm rights to a handful of folks, headline magnate Mel Gibson among them, and the professional pearl clutchers lost their minds. They scream, Trump's Hollywood friend gets his guns back. They completely ignore that the actor's decade-old misdemeanor already put him in the government's penalty box, way longer than many violent offenders spend behind bars. Whether you love Gibson or think he's another spoiled celebrity, the point is, the rulebook finally has ink instead of dust. So how will the new applications get judged? Bondi swears this isn't a paint-by-numbers system. The form asks everything: every arrest, every dismissal, every job reference, every volunteer hour. They'll pull local law enforcement commentary, look at social media footprints, even probe known associations. That last phrase makes some folks itchy. Nobody wants a bureaucrat Googling who you went to the range with last weekend. But it's there, and it's broad. Still, the flip side is that a single bad conviction doesn't doom you if the rest of your life spells stability. If you've been paying taxes, raising kids, and mentoring at the VFW, that context finally matters. The price tag to play is $20, which Bondi's office says can be waived for low-income applicants. $20 sounds almost quaint, until you hear the agency expects about $20 million in startup costs to process the flood. They swear application fees and existing resources make it neutral. Personally, I'll believe that when my cable bill goes down, but at least they know people are watching the ledger. There's a deadline too. October 20th is when public comment slams shut. You've got 90 days to scream, applaud, or suggest tweaks. and I'd love to know if you plan to file a comment. Drop your angle down below, because the antis are definitely typing theirs. Here's the part the nightly news glosses over. Buried in that 48-page legal brick is a paragraph that basically says, if this program runs properly, courts won't need to keep hammering at the constitutionality of Section 9 to 22G1. Translation: the DOJ just gave itself a shield. Remember the Supreme Court's Bruen decision from 22 and the Rahimi case from 24? Those rulings told lower courts to judge gun laws by historical tradition, not modern politicians' feelings, and suddenly, lifetime bans on peaceable felons started looking shaky. Circuit courts have split ever since. 3rd, 5th, and 6th Circuits okay with individualized challenges. 4th, 8th, 10th, and 11th clinging to the blanket ban. When the 10th Circuit doubled down against a Utah social worker named Melynda Vincent, everybody knew the issue was headed for the big bench. Bondi's new path lets the government argue there's a remedy now, so no need to nuke the law. Smart chess move or cynical stall tactic, you tell me. You. Stick with Melynda for a second, because her story punches harder than any press release. 17 years ago, she bounced a $498 check to pay for groceries. Bank fraud technically carries a 30-year max, but the judge gave her probation, which she completed without a hiccup. Since then, she earned 3 degrees, founded the Utah Harm Reduction Coalition, raised her kids, and even teaches college classes. Model citizen, right? Not to Washington. Because the statute says any felony punishable by more than a year kicks you out of the Second Amendment Club, she can't so much as hold a rifle while teaching her son basic hunter safety. Her lawyers filed Vincent versus Bondi, asking the Supreme Court to settle this insanity. The brief points out that in the founding era, dangerousness, not conviction status, was the line. Peaceable people kept their muskets. The petition even notes absurd present-day examples. In Michigan, adultery is a felony. In Tennessee, sharing your Netflix password too many times can be. In Maryland, one anonymous prank phone call crosses the felony line. Does that one lapse make someone unsafe forever? Justice Amy Coney Barrett, before she hit the High Court, wrote that legislatures can block guns from dangerous people, but that power stops there. She used mail fraud about shoe inserts as the example. Vincent's lawyers practically quoted her. If a single bad check kills a mother's right to self-defense, something's wrong with the tradition test. The Supreme Court told the 10th Circuit to re-examine her case after Rahimi, and the 10th Circuit still shrugged and said, "Nah, heller blessed felon bans." So the split deepens, and SCOTUS now has to decide whether peaceable felons stay disarmed forever or get a real hearing. If they side with Vincent, millions automatically get their rights back, and Bondi's new program turns from lifeboat to spare oar. Meanwhile, media loves the Mel Gibson angle because it's shiny. Bondi's office approved his application in March. Rumor says a pardon lawyer inside DOJ balked, got canned, and the blogs ran wild. Yes, Gibson had a misdemeanor domestic violence conviction 14 years ago. Yes, that put him under 922G9. But the new rule sets a 10-year waiting period for exactly that kind of offense. And he cleared it. That leaves us with 2 ways to read the episode. 1. Celebrity privilege fast-tracked him. 2. Celebrity spotlight proved the rule already works. If ordinary Americans see a Hollywood name get a right restored, they might realize the door's open for them too. Take your pick, then tell me in the comments which side of that fence you're on. The bigger picture keeps circling back to balance. Pro 2A folks have hammered for years that punishment should end when the sentence ends. You mess up, you serve your time, you pay your fines, you move on. That's supposed to be the American contract. Instead, we've had lifelong scarlet letters that block jobs, housing, and now self-preservation. Employers run background checks and toss your resume. Banks charge higher rates. Some states won't even let you pick up your kid from school if you've got a felony from the 90s. Gun ownership gets lumped into that pile, treated like a perk instead of a fundamental right. And the public safety argument falls apart once you consider how many disqualifying crimes were economic, not violent. A guy who dodged taxes at 19 isn't the same threat as a guy who shot at a liquor store clerk. We all know it, but the law acts like they're twins. Bondi's rule tries to thread that needle by adding context. Local police can submit letters. Character references matter. Job history matters. For once, the government admits people grow up. I got my first truck at 17, and the first thing I did after clocking out from a Sonic swing shift was bury that thing in a mud hole my dad specifically told me not to touch. He never found the mud because I hosed it off before sunrise. If smartphones and TikTok had existed back then, my ticket history might read different, and who knows what that would do to my rights today. Most of us have that one youthful, what was I thinking story. The new process says one dumb night shouldn't chain you for life. But let's not kid ourselves. The DOJ kept the discretion dial turned high for a reason. They can still deny someone if cops say, "We don't like his buddies," or if a prosecutor digs up allegations that never made it into court. That gray area cuts both ways. It rescues applicants who can prove they're solid citizens, yet it lets the agency stonewall whoever they don't trust. Transparency will make or break this effort. If they publish clear rationales, why Joe got approved, why Lisa didn't, confidence goes up. If approvals look random, folks will yell rigged system, and the courts might agree. Cost also matters. $20 at the front end is fine, but paperwork time equals money, and the agency projects $20 million to stand this thing up. They say the budget evens out once the machine's running, kind of like when the DMV claimed self-service kiosks would cut wait times. Anyone been to the DMV lately? Exactly. Unless Congress allocates fresh cash, DOJ staffers will shuffle cases on top of their existing stack, and wait times could crawl. The rule doesn't promise a deadline, which means applications could sit a year, maybe 2, and momentum dies. If you've waited 5 or 10 years already, another couple years feels insulting. That's why I keep saying comment while the window's open. Demand a firm turnaround time. 5 months? 6 months? Something real. Drop that suggestion on the record so they can't pretend nobody asked for it. Another curveball. If the Supreme Court takes Vincent's case, and insiders think they will, the timetable could collide with oral arguments. Imagine DOJ arguing, "Our new rule fixes everything," while Vincent's lawyer shows a mother with a graduate degree who still can't borrow a shotgun for Youth Day pheasant season. Contradiction City. The justices might say, "Nice start, but you still violated her rights for 17 years. Then drop a decision that guts the whole felon ban structure for nonviolent offenses. That nukes the logic behind the new program's screening hoops, which in turn forces Congress to rewrite 9-22G1. Bondi's office definitely sees that risk, so pushing the rule now feels like hedging bets. Give courts an escape valve so they don't yank the statute. Whether that's clever statesmanship or government seat saving depends on how cynical you are. Let's zoom out and look at raw numbers. Prison Policy Initiative says about 19 million Americans carry felony records. Bureau of Justice Statistics says only about 4.5% of federal felonies last year were violent. Less than a fifth on the state side. Quick math, maybe 16 million people branded felons without ever pointing a weapon at anyone. Think about what that means in neighborhoods where crime actually spikes. Law-abiding parents who messed up decades ago can't legally keep a bedside pistol, but the guy dealing fentanyl on the corner never bothered with the background check in the first place. Gun laws that only bind the obedient don't stop the disobedient. Every honest gun owner knows that. Every anti-gun lobbyist pretends it's complicated. So where does that leave us? If you've got a nonviolent felony or certain misdemeanors and you're past the 5 or 10-year mark, the door's halfway open. File your comment. Gather character letters. Be ready for the application window once the final rule hits, probably early 2026 if the bureaucratic gears turn. Keep records tidy. Taxes, volunteer work, training certificates. Because context now matters. And for everyone who's clean today, think about the precedent. If the government admits permanent bans went too far, future bans just got harder to defend. That helps every gun owner when the next common-sense restriction shows up. But let's stay skeptical. Bondi's plan might help a slice of folks while shielding an overreaching statute from the Supreme Court. If the justices side with Vincent, Section 9 to 22G1 could crumble for nonviolent offenses, returning rights automatically without an application fee, a waiting period, or a background investigation. Ironically, the best outcome for freedom might be for DOJ's own program to become pointless. I'd love your read on that gamble. Do we cheer the incremental relief and hope it expands, or demand the court drop the hammer and end lifetime bans outright? Let me know below. While you're down there, why not click like, share this video with your friends, and subscribe if you haven't already.